Good evening, friends. Thank you for joining us tonight. Welcome to the Daniel Webster Debate Series, hosted by the Georgetown Law Federal Society, and we're glad to announce the Georgetown Antitrust Society. We're thrilled to have them. This should be a ton of fun. This series is dedicated to Daniel Webster, one of our nation's most revered orators and public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is rightly remembered as the great expounder and defender of the Constitution. Our resolution tonight is: should the United States ban non-compete agreements? Tonight, we are proud to host former U.S. Acting Solicitor General Jeff Wall and Mr. Adam Gitlin of the D.C. Attorney General's Office to debate this critical question. Moreover, we are thrilled to welcome the esteemed Judge Douglas H. Ginsburg to moderate this great debate. Following such an important election yesterday, we are fortunate to have such an excellent forum and set of panelists to discuss and debate key legal issues in a serious and nuanced manner. We're thrilled to have all of you. We are deeply grateful to the Federal Society and to Georgetown Law for making the Daniel Webster Debate Series a reality. I now recognize Dennis Azablinski, our Director of Events, to introduce these stellar panelists. Please give them a warm welcome.
Thank you, Brady, and thank you to our great speakers. I also want to say that this event is co-sponsored by the Georgetown Antitrust and Competition Law Association, so we're very happy to have them co-sponsor and help us organize this event. So I'll start with Judge Douglas Ginsburg. He served as a senior judge on the United States Court of Appeals for the District of Columbia, where he previously served as chief judge from 2001 to 2008. Judge Ginsburg was a professor at the Harvard Law School, the deputy assistant, and then assistant attorney general for the Antitrust Division of the Department of Justice, as well as administrator of OIRA and the Office of Management and Budget. Among other esteemed roles, Judge Ginsburg is the chairman of the International Advisory Board of the Global Antitrust Institute at the Antonin Scalia Law School. After receiving his BS from Cornell and his JD from the University of Chicago Law School, Judge Ginsburg clerked for Judge Carl McGowan of the DC Circuit and Justice Thurgood Marshall at the United States Supreme Court. And we're honored to have you, Judge. Mr. Adam Gitlin is the chief of the Antitrust and Nonprofit Enforcement Section of the Office of the Attorney General for the District of Columbia, who will be arguing the affirmative today. Before that, Mr. Gitlin was a partner at Leaf, Brazier, Hyman, and Bernstein, LLP, in San Francisco, where he received the American Antitrust Institute's Award for Outstanding Antitrust Litigation Achievement by a Young Lawyer. Before that, Mr. Gitlin worked as counsel at the Brennan Center for Justice, and prior to that, he worked at the U.S. Department of Justice's Antitrust Division as a trial attorney in its honors program. He received multiple Assistant Attorney General awards of distinction for his work. He received his BA from Princeton and his JD from the University of Michigan Law School. And after completing law school, he clerked for Judge Noel Kramer on the District of Columbia Court of Appeals. So we're honored to have you, Mr. Adam Gitlin. And also joining us arguing the negative is Mr. Jeff Wall of Sullivan & Cromwell and the firm's litigation group and the head of its Supreme Court and appellate practice. Mr. Wall is the former acting Solicitor General of the United States, and he's argued more than 30 cases in the Supreme Court in a number of areas. Mr. Wall has also argued numerous cases before federal and state courts of appeals and administrative agencies. Mr. Wall has also served in the office of the Solicitor General in the Supreme Court. Where he was responsible for overseeing appellate litigation by the United States in the Supreme Court and the Court of Appeals. My apologies. Mr. Wall received his BA from Georgetown University, and his JD from the University of Chicago Law School. Following law school, Mr. Wall clerked for Justice Clarence Thomas on the U.S. Supreme Court and Judge Harvey Wilkinson III on the U.S. Court of Appeals for the Third Circuit. So, as Brady said, I want to, thanks for our speakers for coming, and please give them a round of applause, and let's have a great debate. Thank you. And Mr. Ginsburg, if you want to start with your opening remarks.
Thank you very much. Now, this issue of non-competition clauses has been very much in the fore in the last 2 or 3 years at most. It had been a subject of a number of economic empirical studies over the years, but not really intensely studied until the Federal Trade Commission really put it on the agenda. And the rulemaking that the commission conducted was an extended one in which the number of serious and significant submissions made by members of the public was very large. Studies that were commissioned for this purpose of the rulemaking, studies that had been done, economic analyses produced for the occasion by interested parties and trade associations in particular. The issuance of the FTC's rule raises a number of questions beyond the merits of the proposition tonight as to whether non-competition clauses should be made unlawful, which is to say unenforceable. Because in addition, the commission, having proceeded by rulemaking, has welcomed inevitably a challenge as to its authority to make rules regarding competition subjects. In 1973, the DC Circuit upheld the commission's authority to make rules in the competition area, something that it had not done with any frequency. It had actually abjured any authority in that regard for many years, and then decided that it did have such authority. And the particular rule that was the subject of the rulemaking that as to which their authority was challenged was actually not very important. And then, having won the case in 1973, the National Refiners case, the commission did not engage any further competition rulemaking until this last earlier this year when the commission issued its rule with respect to non-competition clauses. In addition to raising a matter now that may well result in a circuit split, some with another circuit, I guess the fifth, disagreeing with the DC Circuit, if that's what happens, and teeing that issue up for the Supreme Court. It's also been argued by challengers that even if they have, if they have rulemaking authority in general, that this particular rule suffers from defects in terms of being arbitrary and capricious because of its scope. The commission received comments on and rejected various exceptions that it might have built into the rule. And then further, there's the question raised in the ongoing litigation as to whether the rule constitutes resolves a major question as to which the commission would need very clear and express authority from the Congress to issue this rule. So there are various off-ramps in which the rule could get stuck in the course of this litigation. But the question on the merits will persist regardless of the outcome of the litigation. There will be much to debate tonight and even after the litigation. So in the interest of getting us started, I think we should give Mr. Gitlin the floor for roughly 7 minutes. I say roughly, but I've got a clock here as well.
I'm going to take the podium because I understand, does it need to be turned on? I think we're intimate enough, folks can hear me, but mostly because I'm interested in seeing Jeff Pace when it's his turn. First, thank you, Judge Ginsburg. Thank you to the Federalist Society and the Antitrust Club for the invitation. I very much appreciate it. Since I joined the Federalist Society student chapter in my law school 20 years ago, I've always thought it offered some of the best exposure you could get as a student to civil argument on a variety of perspectives. And I'm grateful that I was invited. I understand I'm filling in for Matt Stoller, who's, if those of you who know him, he's probably more accustomed to debating these issues in public fora. So apologies if I don't give Mr. Wall the same run for his money. On the other hand, I like coming in as an underdog. So if I perform well tonight, I hope that you all will consider applying to intern or extern in my office. Your classmate, Sam Bromer, is doing that right now. He can tell you all about it. If I perform poorly, I hope you apply anyway, because I appreciate my courage in the face of overwhelming odds and possible mental health challenges given the events of the last 24 hours. I also hope you appreciate.
I don't know what you're talking about.
I also hope that you appreciate that I've made what you will learn when you enter the profession is perhaps the greatest sacrifice a lawyer can make to be here tonight with you. I'm going to arrive late to a happy hour. To attend. So I need to offer the standard disclosure. These are not the views of the DC Attorney General, and in many instances, what I'm going to begin with is not even really my views. I think there are a lot of excellent advocates who could supply progressive, so-called progressive views in favor of banning non-competes, empowering historically disenfranchised groups, balancing labor as against management. But I think some of the strongest arguments on banning non-competes are those that ought to appeal to a group of conservatives, libertarians, textualists, originalists. So I want to start with textualism. So I think we are, as Judge Ginsburg said, looking at this question not just in the scope of the current FTC litigation, but also in general whether antitrust supports banning non-competes. And there is a response from supporters of non-competes, I think the broadest one, which is that if consumer welfare is reduced, that's when we should worry about a particular piece of conduct essentially violating the antitrust laws. Antitrust should come in where we have an output reduction and consumers are harmed because we have a consumer welfare standard. Those of you taking antitrust, this should be familiar. If that is the main reason that we would not consider employee welfare reductions a harm, then that puts the argument for non-competes in bed with an interpretation of the antitrust laws that is at odds with the text and original understanding of those laws. The text of the Sherman Act, if you have read it at this point, you know, prohibits restraints of trade. It is very broad, and it is very hard to imagine if one looks at the text of the Sherman Act that something literally called a non-compete would not count as a restraint of trade on that simple reading. So if you take the more semantic approach, right, to textualism that we see Justice Scalia and Justice Easterbrook and other proponents do, and you actually apply it to antitrust, non-competes ought to be one of the clearest cases of things you do not want to permit. Now, there are other conservative scholars who try and interpret broad text like that in the statute at issue here against their historical context, right? So what is sometimes called the fixation thesis. This is Lawrence Solom, another luminary of the Federalist Society, formerly of this law school, posited that the constitutional text is fixed when each provision is framed and ratified. And that's true of the Constitution in his view, and that is other scholars have pushed that argument forward with respect to statutory interpretation as well. If we think of the Sherman Act as fixed on the passage of the statute, relaxing the meaning of restraint is not judicial restraint. It defies the understanding at the time, the rule of law, and the textualist reading of the statute. I'm going to talk a little bit more about this, because if we go to the common law backdrop against which all these statutes were passed, the Sherman Act, the Clayton Act, the FTC Act, a lot of the earliest anti-monopoly laws on which they were based, that body of law, are from the states. And the states were trying to protect the ability of suppliers, independent suppliers, to apply their trade. That's what that law shows you. Some years back, I, for a case, had to dig into the North Carolina constitutional prohibition on monopolies, which is one of the nation's first, and had to understand what it meant and where it came from. And I found it very frustrating because the case I was litigating before the North Carolina Supreme Court was about anti-steering prohibitions employed by a large company. That is not what these early cases are about. They don't talk really about large employers. What they talk about is individual suppliers and their ability to apply their trade and the freedom to do that, and that being fundamental to our polity. The leading case is called the case of monopolies. This is Darcy v. Lane in 1602, Sir Edward Coke, and he talks about essentially the right of Englishmen to work for a living and to compete with each other without interference of government grants of special economic privilege. 1711, you see Mitchell v. Reynolds, and this is about a baker's non-compete. For those of you who've taken antitrust or are going to, you're going to see that the rule of antitrust, reason in antitrust, which applies to all but essentially the worst offenses, was articulated in the Addison Pike case, which was really a bid rigging case. And that, all the reasoning in that, pretty much, at the Sixth Circuit by then Judge Taft, and then later on by Justice Peckham on the Supreme Court, comes from Mitchell v. Reynolds, very explicitly. It leans on the analysis in Mitchell v. Reynolds that workers were vulnerable to exploitation through non-competes, and non-competes threatened a worker's ability to practice a trade and earn a living.
This history aligns, I think, with both conservative and libertarian thought in terms of the importance of political and economic freedom. Yes, it's true. Conservatives often do say we ought to be able to contract away just about anything, but even antitrust conservatives, as I think of them. So I'm thinking, for example, of Judge Bork, and Judge Posner, Judge Easterbrook, to name a few. They believe that agreements to fix prices, for example, that's a restriction on the freedom to contract, and that ought to be illegal. And I think part of the reason that there is this exception that we've recognized in American antitrust law is we worry that certain agreements harm others. That is, they have external social costs that are bad, even beyond those to the parties of the agreement. And also because we want you as an economic actor to be free, right? So if you read Hayek and The Road to Serfdom, if you read Milton Friedman, if you read Capitalism and Freedom, you see that they discuss how political and economic freedom have to go hand in hand. And there's actually empirical support since both of them wrote for the fact that they do. I want you to remember that when people like to invoke Adam Smith, when they rail against expanding government to correct market failures, Adam Smith, John Stuart Mill, much of the libertarian tradition, essentially viewed restraints of trade unfavorably. In fact, as harmful to the tradition of economic freedom they thought was critical to a functioning polity. I think there's an argument to be made, yes, that employers have to have a certain amount of freedom too, but we know that companies derive their rights from the flesh and blood people. Employee freedom ought to trump that. And as I'm sure we'll discuss further, it makes sense on the merits to have a rule that bans restrictions on employees' freedom to contract with others.
Thanks, everyone. As a Georgetown alum, it's an honor to be here at the law school and to talk about this topic. And it's a special honor to be able to do it with Judge Ginsburg, because when I was sitting out in your seats as a law student at the University of Chicago, he was then and continues to be a giant of conservative and libertarian legal thought. And so I didn't realize when I said yes to this that I was going to get to sit next to somebody who's a hero, but I am, and it's a real honor. I want to thank Adam. He's done yeoman's work. I feel for him because he has an impossible position. This question really is two questions. Should the United States ban non-compete agreements? All right. Is it a good idea? And do you have the power to do it? Now, logically, the second of those is actually antecedent, but I'm going to save that for a second. On the first one, which is where he's sort of dedicated his time, is it a good idea to ban all non-compete agreements? Look, non-compete agreements have been around since the founding. They have always been a matter of state law. 50 states have taken all kinds of different approaches. Some set restrictions of duration or geography. Some set restrictions on particular professions. He's focused on blue-collar workers. That's obviously where his arguments are strongest. And some states, much more broadly, set aside non-competes. No state, not even the four that have the sort of broadest restrictions, entirely ban them in all circumstances. No state in 200 years has gone as far as the FTC has gone. And why is that? Imagine a chief executive officer who's being paid tens of millions of dollars and who has access to the most sensitive information in the business you founded. And you say that in return for all of that largesse that you bestow on him or her, that if he or she decides to leave, that they don't work in the same sector from one of your competitors for a year or 18 months. To call that contract coercive or exploitative is a crime to English. It is offensive to those of us who grew up in blue-collar families. There is not an American in sight who would not grab that contract and run like they stole something, right? You are intelligent, you are sophisticated, you are well-counseled, you are being hugely compensated in return for that restriction on your ability to apply your trade somewhere else. To say that that contract should be out of bounds is just to say that you don't believe in the freedom of contract. But are there circumstances in which non-compete agreements can be coercive or exploitative on workers who are not making a lot, where there is a large duration or a large geographic scope so that they are effectively prevented from taking jobs elsewhere in the market? Of course there are, which is why 50 different states have taken different approaches over time. That's an interesting debate to have. What are the circumstances in which non-compete agreements should be unenforceable or off the table? That's an interesting debate. Should we take them all off the table? That doesn't strike me as a very hard debate. But again, I'm a lawyer. I'm not an economist or a social scientist. So I don't see much point to asking, should the United States do a thing that it does not have the power to do? The FTC has not relied on the Sherman Act or restraints of trade. Virtually every contract is a restraint of trade. I work at Sullivan and Cromwell. That means I can't work at Davis Polk, and I can't provide legal services unless the people at my firm agree we can take on a matter. That's a restraint on trade, but it doesn't violate the Sherman Act. Unreasonable restraints, which is to say anti-competitive restraints, do, but not every restraint on trade violates the Sherman Act. And the FTC hasn't even looked to the Sherman Act. They've looked to the FTC Act. And what they say is, aha, Mr. Wall, we found it right here in section 6G. We found this provision that says we have the ability to classify corporations for purposes of their submitting public reports. And then it says we can make rules and regulations for the purposes of carrying out this subchapter. Well, that's it. It says we get to make rules and regulations. And you're a textualist. And so welcome to the petard. And now we're going to hoist you. You clearly don't mean what you say. You don't like to read words. We get to make rules and regulations. So why don't you believe in textualism? Well, I do, but I don't believe in literalism. So let me add a few background facts. In 1914, when the FTC Act was enacted, this is decades before the Administrative Procedure Act. In order to give what we now think of as substantive rulemaking authority, Congress attached penalties, and it referred to the rules as binding. If it wanted a housekeeping provision that said the agency could make internal rules, it said rules and regulations, nothing about binding legal effect and nothing about penalties. All right. Skip forward. For 50 years, the agency reads it the way that I'm talking about and does not ever try to make substantive rules to enforce unfair methods of competition until the 1960s and 70s, when the agency does. And in an opinion from Judge Ginsburg's court called National Petroleum Refiners, the DC Circuit blesses that approach. Typical of the era, it does not focus on the text or history of the statute, but it says we are upholding the agency's rule in order to effectuate the liberal purposes of the act. Okay, fair enough. I might have a hard time if Congress hadn't reacted to that by saying, well, there are two things in the statute, unfair methods of competition and unfair and deceptive acts and practices. We will put rulemaking authority in the statute for unfair and deceptive acts and practices, subject to certain restrictions. You have to notify Congress and all the rest, but we're not going to bestow it for unfair methods of competition. Okay? Since that act in 1975, now skip forward for the last 50 years, the FTC has never claimed substantive rulemaking authority under unfair methods of competition. It has always done it under unfair and deceptive acts and practices because that's where it has express rulemaking authority. Now, for only the second time in the last century, the FTC has said, aha, no, we actually do have substantive rulemaking authority over unfair methods of competition. And so here's our rule. That strikes me as wrong as a matter of text, strikes me as wrong as a matter of history, and it doesn't make sense at all of the express amendments to the statute, both in 1975, and there are other specific grants of rulemaking authority that Congress has enacted since in the 80s and 90s. Every one of those would be superfluous if the agency can already make rules under Section 6G. It could already have done everything that Congress has since given it the power to do. So I think, as a good textualist, looking at words in context and over time, I think that the two judges that have set aside the FTC's rule have gotten it right. This is not, Congress has never made the decision to give them this. Now, we can have a kind of interesting debate about that in a world without the major questions doctrine. But once we know that if you've got something that's a major question, you require more of the statute in terms of an agency and what you want to do, we're going to require a little bit more clarity from the statute itself. This seems to me like sort of the easiest case one could find as a judge. Because if ever there were a major question, I would have to think it is where the FTC for the first time asserts substantive rulemaking authority and says, we're going to get rid of overnight of 30 million non-compete agreements, contracts that were bargained for which there was consideration, for which you as business owners and all the rest, you depended on these. You may have paid money for these. We are invalidating them overnight with a very limited exception looking back, and going forward, no exceptions at all. Every non-compete is off the table. And by the way, if we think that any other kind of agreement functions like a non-compete, non-disclosure, any of the rest, those are off the table too. That strikes me as a major question on any plausible conception of the text. And then, is the statute clear? It seems to me obviously it's not. So as a legal matter, it seems pretty easy, and I'll just leave you with this. This is not about non-compete agreements. If the FTC can take a business practice that has been permissible for 2 centuries and that is okay under virtually every state's law, and they can declare that it is an unfair method of competition, they can do that for anything else. It's not just non-compete agreements. It vastly transforms the FTC's authority and makes it a general enforcer by rule of the business community. Now, I have no doubt that alums of the Brennan Center and Leif Cabrazier and the DC AG's office think that that's a good thing. But those of us who hail from the reasonable middle, I think, have real questions about whether we should transform the agency's authority in that way. I urge you to negate this.
Let me do 2 minutes to reply.
I'll take them. So Mr. Wall said a few things, and I want to just focus on a few of them, on a couple of responses. First, I know that a couple of times he mentioned to you all that the states have this crazy patchwork of different kinds of statutory restrictions on non-competes. They vary in terms of even what a court does if it finds a non-compete, right? There's a difference between what we call red pencil, blue pencil, and reformation, right? Red pencil is some states, I can just void the whole contract. And those, contrary to what Mr. Wall may have suggested, some of those have been on the books for decades, these kinds of statutes. There's blue pencil, I can cross out just the non-compete provision and let the rest stand. Or reformation, which is really in some ways the most creative approach. I'm allowed to rewrite the contract so that the non-compete issue is no longer a problem. Now I want you to imagine yourself as the very business owner that Mr. Wall suggested you think of yourself as, and ask yourself whether you'd like one uniform rule, one way or another, perhaps a general ban that may admit to certain exceptions under limited circumstances, or maybe a presumption of anti-competitiveness that you can rebut, or whether you'd like to have to worry, especially if, let's say, you happen to be an employer with an office in more than one state, or an employee, maybe a remote one in more than one state, and you don't want to have to deal with 50 different jurisdictions telling you how to do your business. The second thing I want to point out is goes to what Mr. Wall said about skilled workers and whether they can bargain for more money. So first of all, let's put some empirics on this, right? The empirical analysis that has been done of non-competes shows that about 86% of people don't do anything when they get a non-compete. They just sign the contract because they want a job, right? So we're talking about a vanishingly small number of folks who are actually going to negotiate. Now, skilled workers have a lot of different ways they can negotiate to get paid the marginal revenue product of their labor. They have bargaining power, they can exercise it in different ways. And an important thing that I think the critics of non-compete bans don't always appreciate, but that economists tend to, is that even a skilled worker is not always going to be good at calibrating ex ante how much their worth may increase after they've done one of these deals, right? They said, okay, I'm going to get paid an extra $100,000 in exchange for a non-compete. But all of a sudden, that non-compete may be of 5 years, and over those years, perhaps they become more valuable. Imagine a med school student who graduates with a mountain of debt, and all of a sudden, after a couple of years, is a more promising candidate and ought to be able to renegotiate, but can't because essentially they are caught working for that particular hospital. Mr. Wall mentioned that non-competes have been around since time immemorial, and all restraints of trade, all contracts are restraints of trade in some manner, right? And I think the example he gave was that while he's working for his law firm, he can't work for other people. I think that's right. I just think that's not persuasive at all, and it wasn't persuasive to Justice Peckham in 1899, because in Addison Pike, when it hit the Supreme Court, again, one of the arguments was, look, Congress essentially, there is no power to restrain trade in this manner. To restrain the ability to restrain trade, that is to restrain the ability to enter into contracts. And And the response from Justice Beckham was, yes, okay, of course. It can't be that every restraint of trade is illegal, because while you're working for an employer, you have a restraint of trade between you. But that still admits to some liberties of contract that have to be restrained in some way, and in ways that would limit economic freedom and harm competition. And as to the FTC litigation itself and basically the viability of the rule, one thing I think it's important to note is that even the district court in the 11th Circuit, which agreed with Mr. Wall on the major questions point, the fact that this raises a major question, which I think is likely incorrect, did recognize that this is a subject matter in the FTC's wheelhouse. Just because the FTC, like arguably other antitrust enforcers, has not used all the power, all the tools that it could since essentially around the 1970s, 1980s, we saw a bit of a shift in the way antitrust enforcement was thought of, doesn't mean that that tool is no longer a reasonable way of using power that it has been given by Congress quite explicitly to target unfair methods of competition. History and context has shown that the Congress wanted the FTC to promulgate binding regulations about the economy. The fact that it declined certain opportunities doesn't mean that it's not entitled to do so. And I think in a situation like this, where the FTC spent 6 years of study, considered something like 26,000 comments from the public, and reached a rule with carve-outs that's going to lower consumer prices and is projected to yield something on the order of like $500 billion in higher worker earnings over a decade, that the default rule that it chooses should be what businesses have to work with. And if they want to propose carve-outs to that, potentially they can, but it's not as if the FTC hasn't done its homework.
Thank you, Mr. Gill. Well, that was not 2 minutes, but perhaps you would like some sword.
Look, I'm happy to throw it open to questions. I will say only that there are two grounds on which we've challenged the rule. The first is the lack of statutory authority. I already talked. The second is that the agency has acted arbitrarily and capriciously in sort of two ways. One, by banning all non-compete agreements, even though the record that it assembled does not show that all non-compete agreements are anti-competitive. It is a record that focuses on, as I say, certain kinds of non-compete agreements, typically involving lower paid blue collar workers, and then extrapolates from that if those agreements are anti-competitive, well, so too others, though they may be less anti-competitive. And that seems to me wrong. You can have an agreement with a CEO that is not anti-competitive of the same sort as with a blue collar worker. And then we have also said, to the extent that they have sort of tried to show that even those agreements are anti-competitive, they've relied on a number of fairly limited studies and stale data. And so when, Mr. Gillen says, oh, they've done their homework, one goes back to the file. It really isn't true. To say they considered 26,000 comments is to say that they received 26,000 comments and then said, we think they're wrong for the reasons we gave in our proposed rule when we cited a handful of fairly old studies, all of which seem to have an axe to grind and all of which concluded on the basis of very limited and stale data that non-compete agreements as a whole are unreasonable and anti-competitive. To say that this was the sort of economic study that one would find in a serious economic center or university on non-compete agreements is, I think, to be overly generous to the FTC and what it did here. It has never had any purview over non-compete agreements. At the same time it finalized this rule, it undertook the only 2 enforcement actions it had ever undertaken with non-compete agreements. One of the key enforcement actions, the non-compete agreements, had already been declared unlawful under Michigan state law. In one of them, state law had already stepped in and said it was an unreasonable agreement. So again, I am not here to defend the idea that all non-compete agreements are reasonable. I am here to defend the idea that they are not all unreasonable. The FTC's evidentiary record doesn't show anything to the contrary. And as interesting as the debate is, the FTC has never been given authority by Congress to regulate by rule unfair methods of competition.
So I take it your position then is that not only that some non-competition agreements may be prohibited as maybe unreasonable or coercive in some respect, and how do you just distinguish between the two that you staked out here?
So the way that most state courts have looked at them is to ask, what sort of interest, it's a multi-factor test, to be sure. What sort of interest has the employer advanced? A typical interest, for instance, is training, right? When I hire someone into the appellate practice at Sullivan and Cromwell, I intend to spend significant time working with them on how to write appellate briefs. I'm investing a lot of my time and effort into them. Now, that information isn't confidential. Those certain other things about the way I price cases or the way I pitch business is confidential. But there are businesses where the information is far more proprietary. Think about the tech field, for instance, or the medical field. And so, does the employer have a legitimate interest in trying to protect some sensitive and proprietary information? What's the duration of the non-compete agreement? Is it something like 6 months or 12? Or is it something like 24 or 36 months? And what's the geographic restriction or the sector restriction? Does it prevent you from working anywhere, or does it just prevent you from working for direct competitors or people who are sort of literally on the other side of the street? And some of those factors can sometimes make for a close call. But I think that that's the right way, in essence, to look at these. Does the employer have a legitimate interest? And is the agreement tailored in some reasonable way to that interest? Or has the employer really tried to go overly broadly in a way that will lock the worker into the job, sort of unfairly, in a way that doesn't really match up with the employer's interest? That's the way most states look at it, and I think that's the right way to do it.
Would you concede that the non-competition agreements typically found in the fast food industry for servers and cooks and so on at McDonald's and the others are probably not reasonable?
So having started my career at McDonald's, now granted, I was in the drive-through, but we did not have a non-compete agreement. And as far as I know, I'm not, maybe Mr. Gillen will correct me, and there is some major fast food chain that has one, but I don't think that those are typically the industries where you see a problem. I think it tends to be more like unionized blue collar industries, and or even non-unionized, but blue collar mechanics, bakers, that sort of thing. And there, I think you can find instances where some of them look, by my lights, if I were a judge, unreasonable.
Well, once you've created this distinction, you have also created a distinction between a rule and adjudications, between one-off, one episode, and infinitely costly proceedings over thousands of cases. And of course, most of them will never be brought because the employees are not in a position to litigate.
I mean, look, that's the cost on one side. On the other side, you have the cost of banning a type of contract that in many circumstances does serve legitimate rationales, where you're actually aiding competition by virtue of the agreement. And so a number of the commenters to the FTC asked for various carve-outs, senior executives, independent contractors. And so there were a number of ways you could have, even if you wanted a rule, where you could have tailored so that the rule picked up only categories that were more likely to be problematic. I would still say that you have to have evidence to support banning each of the subcategories. Otherwise, it's arbitrary and capricious. But the FTC hasn't even tried to take a sort of middle ground approach.
And Mr. Gitlin, you would admit of no exceptions?
For purposes of this evening, I think no exceptions is something that ought to prevail for precisely the reason, Judge, that you get to, is that the alternative is many individual actions that consider the particulars of every single employee, potentially every single employee's situation. And that kind of extensive multi-factor test may work in the hallowed Supreme Court and appellate practices of law firms in DC. But those of us who actually have to do intake and see day by day folks who see that they have a non-compete agreement, a non-compete clause in their employment agreement, and want to know whether or not it's problematic, know that it takes an incredible amount of resources to evaluate what in most instances is going to be a non-compete agreement clause that the employee had no idea they were signing. They were used in up until a few years ago in basically every, not just some fast food franchises, basically every fast food franchise in this nation. And you're going to have to choose a rule one way or another, right? There are rules that have incidental burdens on business practices, and yes, there are costs of compliance. There are also regulator costs, that is to investigate each of these. At this moment, the District of Columbia largely bans non-competes. It's actually very convenient. Every time a non-compete, a straight non-compete comes in, I refer it to our workers' rights folks. They like bright line rules. They're not like civil antitrust lawyers. They like bright line rules they can very easily apply, and they take care of it.
Well, that works in a commerce-free zone.
Yeah,
Like the District of Columbia, but where people actually make things and do things and are paid, let's say, $151,000 for doing so, you would still say they need the protection that you're offering them?
I think, well, two things. One, I think you have to choose a heuristic either way. You need to have some rule. And that may mean more often than not, you are choosing a rule that's going to burden a few people. So that means that some skilled workers are going to have to find a different way to extract the bargaining power, whatever they can get from the bargaining power they have from being, let's say, some sort of specialist, which I think is what you're getting at, Judge. And I will say that just as a matter of practice, these rules aren't even necessarily followed when they're lesser, right? So in the District of Columbia, you're supposed to, for certain kinds of specialists, highly paid workers, you have to give notice of the fact that you're going to put the non-compete in. And wouldn't you know, employers aren't always good at following these sort of rules that are somewhere in between, either yes, you can do it, or no, you can't. We find employers that ought to be very well counseled violating these rules not infrequently.
Sure.
I just wonder how far one is willing to take this rules-based approach without regard to the competitive effects of a particular agreement. What if you have a non-disclosure agreement that says when you go to your new employer, you can't disclose the proprietary information you learned in your old job? Do we want to rule that those agreements are always okay or never okay? What about the agreement that says you can't recruit away the people that you worked with to your new job for some period of time? Always okay, never okay. What about the rule that says you can't poach the clients that you only had access to because of your old job for some period of time? Always okay, never okay. The question that these laws should be asking are these agreements anti-competitive? And it strikes me as wholly unrealistic to think that that answer will always be the same, regardless of the particulars of an agreement. But by the way, I will go into the lion's den and I'll take the fast food example and I'll eat the hypo. And I'll be willing to say that the drive-through worker shouldn't have non-compete agreements. As long as Mr. Gitlin's willing to grant me that when I open my small grill in the small town where I grew up, and the guy applies to be a fry cook, not knowing how to do anything, and I agree that I'll train him as a fry cook, as long as he agrees to work for me for some period of time and not go to Moe's Grill on the other side of the street, that's a perfectly reasonable agreement for me to enter into as a small business owner. And indeed, it's the kind of thing that if I didn't have, I wouldn't hire that guy walking through the door. And are we all better off? So I'll take the tough hypos as long as he's willing to say that all of these agreements, no matter how competitive or how reasonable, are off the table. And that strikes me as nuts.
We have a few minutes for questions, do we not? Yes, so if that's other questions, other perspectives.
Question, I guess for Mr. Gillen, because I went to Michigan, so go. If this doesn't get challenged, it goes through FTC bans non-competes. What happens if someone is employed in an American company and then goes to work in a foreign competitor? Does the FTC, are they able to enforce this against if they leave the country? I guess, like if you work in Detroit and then you go work in Windsor in the same automotive industry.
Unlike me, Mr. Wall is actually counsel in one of these pending cases, so he'll probably know the answer.
Oh, I have a view. I'll answer it. Look, should the FTC be able to apply its rule extraterritorially? No, we have a presumption against extraterritoriality. That said, the FTC has taken the position that although its rule would invalidate 30 million non-compete agreements overnight, that is not a retroactive rule. They say it operates only prospectively because it only annuls them going forward from the effective date of the rule. Now, if that's your position on retroactivity, I have zero confidence what the FTC will say on extraterritoriality. But the right answer is no, it cannot enforce its laws overseas with respect to foreign employers.
Yeah, I think you'd have trouble doing that as a general matter for any antitrust related rulemaking. It would be hard. But it's also the case that the same rationale, I think, in a lot of ways would apply. That is to say, yes, I think there are certain things that employers probably ought to be able to do to ensure that whatever training they get from their employees, they can essentially recoup or guard in some way without actually restricting them from working for a competitor. So some form of cooling off period, some form of NDA, in addition to all the tools they already have, right? They can already sue for sharing the trade secrets of how Mr. Wall grills his sausages. They can sue for tortious, Mr. Wall could sue them for tortious interference. There are employers have tried all sorts of interesting creative tactics like you would expect,
So
suing for
you just
liquidated
said-
damages.
You just said perhaps a cooling off period. Did you just give away the store?
No, I don't think so. I think there have been for basically the history of the support of non-compete bans, there have been those who have supported in certain circumstances, allowing for mechanisms that essentially allow the employer to keep the benefits of the training they've invested without the more extreme alternative of banning competition for working for any competing employer altogether. And I think those are very feasible, in addition to other things like that you can do to encourage employees to stay, like equity-based compensation structures that encourage employees to maximize their own value. There are alternatives to simply having this draconian, I can impose a rule that limits you for potentially 5-10 years for working for anyone else or for yourself, even if you want to work otherwise going to be the most innovative producer of the good.
So I might, for instance, offer my employees shares based on their term of employment, accruing every month, let's say, but vesting only after they've been with me for 10 years.
So I think that presents an interesting question, and I don't know that the FTC would consider it, that the FTC's ban would cover that explicitly. The FTC may well one day argue that it does, but traditional antitrust principles would still be available if they thought that it was in practice anti-competitive.
So I love the concession that cooling off periods and non-disclosure agreements and all the rest are fine. I don't understand what the difference is between a cooling off period and a non-compete, but I will say that is more reasonable than the position the FTC has taken. In their rule, what they say is, well, non-disclosure agreements and non-poach agreements, those are all fine, as long as they're not the functional equivalent of a non-compete, which is to say, if in practice they prevent you from taking a job that you want to take, well, then they look to us like non-compete agreements and they fall within the scope of our rule. And so I think, like, if we're going to hold these out as realistic possibilities, we have to recognize that they will at times restrain your ability to take other jobs. And if that is the basis for the complaints about non-agreements anyway, then I don't understand why it is that all of these agreements across the board are not impermissible. I imagine I allow the employees to have some equity share and invest if they take certain kinds of jobs or if they stay for a particular period, but not if they go to a competitor within 2 years after they leave. Surely the FTC will say that's just a non-compete agreement by another name.
We have time for another question. Yes.
Arbitration clauses, as I understand them, frequently appear non-compete clauses frequently appear alongside arbitration clauses, as I understand it. And I wondered if, in your all opinions, that affected the practical availability of the state law test that Mr. Wall has championed.
So I don't think so. I think back in the day, there was a common argument that they functioned together as in a sort of coercive way, because there was this sort of idea that employees couldn't access arbitration and thereby exercise their rights. I don't think, at least among economists, that notion is as much in vogue anymore, though we'll see. Maybe Mr. Gillen thinks it is. Arbitration is easier to access than courts. It tends to be cheaper, and you actually have the rise of plaintiffs' firms now that are using mass arbitrations by rounding up lots of employees in order to force employers to get rid of arbitration clauses, because now the employers have decided, oh, it's actually better for them in court, and the arbitrations tend to be more plaintiff friendly. So I think the evidence on whether arbitration is sort of worker or plaintiff unfriendly is at the moment pretty mixed. And I will say, just like for non-competes, there can be good reasons to go to arbitration and there can be bad reasons to go to arbitration. And it seems to me that those agreements, just like non-competes, cannot be sort of taken as a whole across the board without knowing more about the relative bargaining power of the parties, the interests that that is designed to serve, and how it's functioned in the workplace, and whether it's actually limited people's ability to get relief or not.
One of the advantages often seen by employers in particular is that it's not a public proceeding. So if the whole thing is about the abuse of their confidential business information, they'd rather have that carried on in a private arbitration rather than in court. And others, yes.
I have to say that I think that Mr. Wall's position is somewhat ignoring the question. You basically swat away early in your argument that the United States does not have the authority to do so, but you are pretending the other normative question doesn't exist, which is that can Congress ban non-compete agreements? Sure, the agency, that's a whole question. I understand why the entire debate has focused around the agency's ability to make non-compete agreements banned. But can Congress do that? And if they can, since you have agreed with that's a flip, Judge Ginsburg's questioning of that there, are sort of non-compete agreements that are, unreasonable restrictions on an employee's ability to go to other employers. So why cannot Congress do that? And if they can, why shouldn't you agree, since you believe that there is an unreasonable restriction on workers' rights within the non-compete area?
Can Congress do it? Yes, of course. Under the Supreme Court's current understanding of the Commerce Clause, non-compete agreements taken in the aggregate affect interstate commerce and hence would be regulable by Congress. So they could ban them tomorrow. Why has Congress never undertaken any serious effort at that? Well, that question sort of answers itself. What's the last sort of economic arrangement that is common in virtually all, at least 46 of the 50 states and not the district, that Congress has just sought to outlaw? I mean, do we have examples? And the reason is because typically where you can have contracts that serve either reasonable or unreasonable ends that are either competitive or anti-competitive, Congress does not ban or act as a category, it tailors. Could Congress pass a federal statute that mirrors some state law that sets geographic restrictions, temporal restrictions, that sets wage thresholds, right? They'll be presumptively unenforceable if the worker makes below a certain amount. Of course, things like that, like you could easily imagine a rational Congress doing. It is very difficult to imagine a rational Congress banning non-compete agreements. That is how extreme the FTC's position is. I mean, I have no doubt it does not seem extreme to Senator Sanders or Senator Warren, but to most senators and representatives, it would strike them as quite extreme.
And California has done just that, has it not?
So California has a virtual ban,
Yeah.
but it does allow non-compete agreements in certain instances. For example, if you sell your business, right, we can require you as the former owner of your business not to compete with the new owner of the business for some amount of time. Even that agreement, which California concedes is perfectly reasonable. Why would you buy a business only to find that the person starts a new one and competes with you? Even that's off the table under the FTC's ban. But you're right, there are 4 states that disallow most non-compete agreements, and California is one of them.
And Mr. Gitlin, you were going to say.
I was going to say, so California is always an interesting example because despite this non-compete ban, somehow the tech industry has flourished there. And in fact, there are, without saying whether or not there's a causal relationship there, it certainly hasn't stopped the tech industry from flourishing there. I just want
Actually, but their reaction was to enter into no poach agreements, right?
which
Which were totally unlawful.
which were totally unlawful. That one bad followed another does not make the other one valid.
And non-disclosure agreements.
Yeah.
you know, I think there are, there's another point that Mr. Wolver has, that I think he's now done a couple times, it merits mentioning, because it's easy to say that, yes, okay, the welfare results are not totally on one side or on the other. There are occasionally some good things that non-competes can do,
See,
but that
say
can be.
it, it's okay.
Yeah. That can be said of price fixing too in certain situations. If producers agree to maximum prices, that can be welfare enhancing, okay? The entire raison d'etre of the NCAA up until recently was essentially a price fixing agreement that was supposed to be consumer welfare enhancing, because otherwise you don't have sports teams unless they can all agree to pay athletes a salary of zero. All right, there can be things that the Supreme Court has basically said are per se illegal, right? Because we need a rule, because most of the time we recognize that they're problematic, that they're bad for consumer welfare, and that they're bad for workers, and that they're bad for employers as well, to the extent they are competitors and want to be so in a free market. That doesn't mean you simply say, okay, we have to just, you know, throw up our hands and let it go. It means you choose a rule and you do your best where possible to find some carve-outs, understanding that you might have to foreclose some pro-competitive conduct.
Brady.
I think we're good to close, Judge.
Yeah, I think we've pretty much laid out the issues, and you've done a great job of making it clear what the arguments are on both sides. So thank you, and please join me in thanking our debaters. I also think it's a real tribute to the Federal Society and to this chapter to have initiated the program, the series of debates. I hope that other chapters will